Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. There have been so many losses of late, and so many cases as well. So the circuit gods decided to give me a relatively short week with all wins for non-citizens to boot. Rejoice, weirdos who listen to the podcast. Rejoice. Pretty much all Friday publications, though. Naturally. Not only that, but by the time you hear this, I believe that there will be a new appellate immigration judge at the BIA. None other than Matter of Lopez, who before his recent elevation to the highest bench in immigration land, was our wonderful protagonist in The Return of the FAC, Mr. Nikenglafak. I can only imagine that his organization will expertly conclude the saga. Everything I know about appellate I.J. Lopez speaks to a brilliant mind and a caring and kind soul. Congratulations, Judge. I'm just happy I beat UIR to the announcement. And finally, the National Immigration Litigation Alliance of Trina Real Muto's special episode interview fame just published a practice advisory to help all of us litigate in this new post-Wilkinson world. Links in the show notes. On to the show. Our first case, Khalil v. Garland, published by the First Circuit on March 29th, 2024. This case is about nexus, mixed motives, and religion. Mr. Khalil is from Egypt and is a Coptic Christian. Quote, because of gold jewelry that he wears and 2 visible tattoos of a cross on his hand, Mr. Khalil was recognizable to others in his community as a Coptic Christian. End quote. He worked in a hospital lab in Egypt. He came to the United States and sought asylum. The reason stems from an issue with an imam. One evening in early May 2016, the imam, quote, came to the lab to request blood work from his unmarried 14-year-old daughter. The blood work revealed that the imam's daughter was pregnant. When Mr. Khalil informed the imam of the results, the imam became irate and demanded that Mr. Khalil change or destroy the results, which Mr. Khalil refused to do. End quote. Then, quote, about 1 week later, a different female patient visited Mr. Khalil's lab requesting blood work and a vaginal sample. After Mr. Khalil drew the patient's blood, he told her to sit behind a curtain in the room, change, and wait for a nurse to come in to collect the sample. The patient started to undress in front of Mr. Khalil and accused him of sexually harassing her. End quote. When he tried to leave the room, he found 4 Muslim Brotherhood members on the other side of the door waiting for him with sticks, and they said that they were the woman's brothers. They called Mr. Khalil an infidel and demanded that he convert to Islam or marry their sister. When he refused, the men got angry and almost broke his arm. They beat him up pretty bad, and when they finally stopped, they said that Mr. Khalil, quote, should have listened to the imam and changed the results of the blood test for his daughter, end quote. All goes back to the imam. Mr. Khalil was treated for his injuries in a hospital, requested leave from the hospital, and he received 1 year's leave. He was already married and he moved to a different part of Egypt with his wife and his sons a week later. He lived there for 2.5 months, but during that time he was told by a friend who had helped him after the beating that his, quote, attackers were looking for him at Mr. Khalil's lab, and they threatened to kill him if they ever found him unless he converted, end quote. He came to the United States on a tourist visa shortly after that. He affirmatively applied for asylum with USCIS, but USCIS referred the matter to an immigration judge by commencing removal proceedings. The principal claims for asylum were that Mr. Khalil had been persecuted on account of his Coptic Christian religion and that he would be tortured if forced to return to Egypt. And of course, persecution or a fear thereof on account of one's religion equates to fear on account of a protected ground. They're not always particular social group claims, guys. It seems like the testimony before the immigration judge was pretty abbreviated on agreement by the parties. And it seems that it came out on cross-examination before the immigration judge that Mr. Khalil had also been harmed due to his faith when individuals threw rocks and cursed at him while he was on his way to work or church multiple times. The IJ seemed suspicious of Mr. Khalil's credibility, but expressly declined to make an adverse credibility finding. That means that he is assumed credible. First hurdle, down. But the IJ didn't see this as a religion claim. The IJ thought that Mr. Khalil and the Imam were just having a personal dispute. The religion stuff was secondary and minor at best, incidental in asylum legalese. The BIA affirmed. The First Circuit did not agree. Well, I believe that the IJ and the BIA conducted the correct nexus analysis, focusing on whether a mixed motive existed and whether religion was intertwined with a personal reason for Mr. Khalil's experience with the Imam and the Muslim Brotherhood. The First Circuit just believes that the agency was wrong. Quote, the record compels the conclusion that religion was one central reason for Mr. Khalil's beating, end quote. I went deep into this case because at the time I did the summary, it was the only case I had for the week on a Friday afternoon. But it's interesting, so I'll keep doing it. Why did the First Circuit so hold? Well, under First Circuit precedent, quote, an applicant suffers persecution on account of a protected ground when it is impossible to disentangle a non-protected motive and the protected ground, end quote. That's just one way to succeed on a mixed motive claim. But it's applicable here, and the standard, quote, applies to personal disputes, end quote. To be one central reason, an asylum seeker, quote, need not prove that a protected ground was the most important reason, end quote, for the harm suffered. This case might already be one of the more important mixed motive cases that I've discussed in a while, and we've only just begun. For mixed motive cases, the protected ground, like religion, can't be an incidental reason for the harm or fear, but like anything higher counts, right? Anyway, like I said, the First Circuit believed the agency conducted the correct mixed motive analysis. Now true, quote, it is not enough for the agency simply to invoke the one central reason standard in its nexus analysis while simultaneously reasoning that the persecution cannot be motivated by a protected ground simply because a non-protected ground for the persecution also exists, end quote. So remember that. Just because the IJ or the BIA cites the right standard, if what it did in practice doesn't really recognize a possible mixed motive claim, the agency errs. But that's not what happened here. The agency just came to the wrong conclusion, reasoned to the First Circuit. Yes, the Imam and the Muslim Brotherhood people wanted to destroy the blood test. But also, Mr. Khalil's, quote, attackers demanded he convert, beat him when he refused to do so, demanded again that he convert, and beat him more intensely when he again refused. The attackers' own statements show that, regardless of whatever else prompted the beating, Mr. Khalil would not have been harmed had he agreed to convert, end quote. Back on this whole theme as of late. Even if the initial thing that results to the harm occurring is not a protected ground, it can transform later. And fair enough here, but what about when asylum seekers aren't blessed with attackers who decide to orally comply with the demands of the asylum nexus standard? Well, just remember that the analysis requires consideration of, quote, the record as a whole, end quote. So the case here is getting remanded for the IJ and the BIA to conclusively determine whether the harm was bad enough to equate to past persecution, and whether indeed Mr. Khalil can safely relocate in Egypt. I suppose the IJ and the BIA must consider it all alongside that other incident where Mr. Khalil was attacked on the way to church. The First Circuit doesn't see that as past persecution in and of itself, especially because the record seems a bit unclear whether Mr. Khalil was ever actually hit with the rocks. But combined with the Imam and the Muslim Brotherhood stuff, that might be past persecution in totality on remand. Not only that, but the First Circuit sees a potential Convention Against Torture claim. Because although it doesn't appear likely to the First Circuit that the Egyptian government will torture Mr. Khalil themselves if he returns, there may be a likelihood that the Muslim Brotherhood will, and that the Egyptian government or representatives of it, like the police, will be willfully blind to that torture. And that counts. Maybe this exists, maybe it doesn't in Egypt. The problem with the First Circuit here is that the BIA had to review this whole issue de novo. It's a mixed question of law or fact. The likelihood that a person will be tortured is a question of fact. But, quote, whether such harm rises to the level of torture and whether the government's role renders the harm by or at the instigation of or with the consent or acquiescence of a public official are legal questions it reviews de novo, end quote. And remember, if you're challenging a decision, you always want to be in de novo land. It's a mixed question. There are factual and there are legal ones, and after Guerrero-Lasprilla and certainly Wilkinson, that means the BIA must review an IJ's CAT determination de novo without any deference to the IJ's findings, at least when it comes to the government action or inaction prong, and whether what happened rises to the level of torture. Because the BIA did not do so here, it's getting remanded. Seems like the BIA reviewed everything under a clearly erroneous standard, a much more deferential standard of review. The BIA should watch out on remand, too. Because yes, while the Muslim Brotherhood might not be very well loved by the Egyptian government at the moment, evidence of what a government is doing at the high level does not always cut it to undermine a CAT claim. Quote, lower level officials may still consent to or acquiesce in torture notwithstanding higher level officials' attempts to address some violence, end quote. And that still counts for CAT purposes. This is the case even though Egypt has designated the Muslim Brotherhood a terrorist organization after the massacre committed on the Muslim Brotherhood by the Egyptian government in the early 2010s. Plus, Mr. Khalil had an expert that reported that Coptic Christians have great difficulty in getting police to protect them. The First Circuit is rarely succinct. Congrats to Mr. Khalil. Good luck on remand. And of course, congratulations to Sahir J. Macarius and Audrey Botros for petitioner, along with ACLU Massachusetts and the Harvard Immigration and Refugee Clinical Program on amicus. And that is Khalil v. Garland. Which means we next have Almanzar v. Attorney General of the United States, published by the Third Circuit on March 29th, 2024. The Third Circuit published a decision quite late on Friday, and it's a weird one, procedurally. It was a win for the non-citizen that occurred all the way back in July of 2023. The petitioner thought it was so important that it should be made precedential, so they filed a motion for the Third Circuit to make the case precedential, and it was granted, and here we are. So now this decision has the force of law, and here's what it says. New Jersey's second-degree robbery statute, New Jersey Statute Annotated Section 2C:15-1A, is not a crime involving moral turpitude. And it's going to mean that Mr. Almanzar will very likely not lose his green card. It all begins with Matter of Diaz-Lizarraga, that pesky 2016 BIA decision where the BIA changed the decades-old definition of a theft-type CIMT and held that no longer does the CIMT definition mandate that the criminal statute require an intent to permanently deprive. A theft-type crime that criminalizes a mere temporary taking will now do. The Third Circuit held, however, in Francisco Lopez v. Attorney General of the U.S. in 2020, that to the extent that that new rule is okay, it can only be applied prospectively, not to pre-2016 crimes, as was at issue here. Because of that, because of Francisco Lopez, the immigration judge held that New Jersey second-degree robbery is not a CIMT, at least in this case. But the BIA reversed the IJ on appeal. In a sentence that does not bode well for the BIA, the Third Circuit notes that the BIA, quote, purporting to apply the categorical approach, held that robbery is now, and always has been, a categorical CIMT, end quote. But that is not correct. Proper application of the categorical approach requires an analysis of the New Jersey statute. And that statute, explained the Third Circuit, essentially criminalizes regular New Jersey theft under 3 alternative aggravating circumstances. That's what makes it New Jersey robbery. Seems then that the Third Circuit believes that those 3 separate aggravating circumstances are elements rather than means, making the statute potentially divisible as to how the robbery occurred. But it doesn't even matter, said the Third Circuit, because, quote, none of the elements listed at Section 2C-15-1 match the generic definition of a CIMT, end quote. Again, all the different ways incorporate New Jersey theft. And New Jersey theft happens when someone unlawfully takes property with the purpose to deprive that person of the property. Deprive, in turn, is defined to include a permanent taking, but also includes conditions where the person, quote, withholds property with the purpose to appropriate a substantial portion of its economic value, end quote. Criminal, to be sure, but not morally turpitudinous, under decades and decades of precedent that the BIA decided to change in 2016, said the Third Circuit. Which just goes to show you how dang unconstitutionally vague and malleable that pesky CIMT term is, no? Nor do the aggravating factors make this non-turpitudinous theft turpitudinous when transformed into robbery. For example, 2 of the aggravating factors essentially require bodily injury or the use of force, but that force is so slight under New Jersey law that it can't transform the crime into a CIMT. The New Jersey Supreme Court itself has explained that, quote, a thief commits second-degree robbery, but not simple assault, if he or she only threatens another with bodily injury regardless of its seriousness, end quote. The final aggravating factor of the New Jersey robbery statute very broadly criminalizes theft while threatening to commit or committing any New Jersey crime in the first or second degree. And while that is a lot of crimes, makes it a lot easier for New Jersey to imprison people for robbery. But inevitably, lots of those first or second degree New Jersey crimes that can make a theft offense a robbery are not CIMTs themselves. Pretty much a non-starter of a subsection for CIMT purposes. To be uber clear, said the Third Circuit, it is not the case, even under BIA precedent, that, quote, commission of or threatening to commit another crime inherently intensifies the situation, end quote, and makes a non-CIMT a CIMT. That's just not how the categorical approach works. Crimmigration arguments at their finest. Glad it was published. So double congratulations to Michael Anzulis from Seton Hall Law School and Stephanie E. Norton from Cardozo Law School on this win and on winning their motion to make it precedential. And that is Almanzar, the Attorney General of the U.S. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB-5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad, while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt, to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures. But let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines. It can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Are you tired of answering your own phones? Or of wasting your valuable time on unqualified consultations? Staffy Live is the only 24/7 live receptionist and intake service specialized on immigration law. Staffy Live specialists are highly empathetic, bilingual individuals who know how to deal with adversity, have a background in client care, and are trained to qualify callers by asking the right questions. Staffy Live goes one step ahead in only scheduling qualified consultations on your calendar and then doing follow-ups when needed. Staffy Live is giving a 15-day free trial for any law firm interested with no strings attached. To apply, visit www.getstaffy.com. That's GETSTAFI.com and click on Get Started. Make sure to put in the code FREE. Links, of course, in the show notes. Our final case is Melara v. Mayorkas, published in the Central District of California way back when, in 2021. It's a district court case, and it's one that I've been saving for a while now, when I had a short week. This case was highlighted by Ira a few months ago, and, well, I'm always interested in something that chips away at the draconian, nearly waiverless, false claim to citizenship and voting removability provisions. This is such a case, in the naturalization context. And well, the fact that it happened in my backyard in Southern California is just icing on the proverbial judicial cake. Judicial cake. Mr. Melara was born in 1959, and for a long while assumed that he was a native and citizen of El Salvador because he had a Salvadoran birth certificate. When he was young, however, his paternal grandmother told him that actually he was born in Puerto Rico. Prior to 1979, he went back and forth from El Salvador to the United States many times, getting into the United States by saying he was a U.S. citizen. He snuck in without authorization in 1979, where he admitted that he was from El Salvador, and he was deported from the United States. He didn't claim U.S. citizenship at this time during these deportation proceedings in 1979. But then at some point between 1979 and 1986, the mysterious grandmother gave Mr. Melara a birth certificate stating that he was in fact born in Puerto Rico. That would mean that actually he's a U.S. citizen. But he's not, because that birth certificate is fraudulent. His grandmother didn't tell him that it was fraudulent, but did tell Mr. Melara that she was giving him the birth certificate because she didn't want him to get deported again. It looks like he thought it was valid. Mr. Melara used the birth certificate to obtain a U.S. passport in 1986, and he then used that passport to travel to and from the United States multiple times. And of course, all of this meant that he couldn't benefit from amnesty or SAW or similar programs legislated significantly by Republicans, and that provided generous paths to non-citizens to legalize their status in the 1980s and 1990s. Seems like Mr. Melara made quite the life here in the U.S. and worked hard. He voted in multiple federal elections. He testified ultimately in federal court that he did so because he thought that he was a U.S. citizen. He told multiple U.S. government entities in multiple contexts that he was a U.S. citizen born in Puerto Rico. But after his passport wasn't renewed, It seems like he became unsure about what was going on with his U.S. citizenship, and in the late 1990s he started applying for immigration benefits through his wife, who was a U.S. citizen. Seems like he was trying to eventually adjust to LPR status through his wife. And in the I-130 petition and related documents filed for him, he said he was born in El Salvador, and he said that both his parents were too. So that's not looking great. He finally applied to adjust to LPR status in 2001. Maybe because 245I was expiring, and he needed to get his application in, right? In that application, he said that he and his mother were born in El Salvador, but that his father was born in Puerto Rico. I'm not sure Mr. Melara knows exactly what the truth of his birth is. Then again, do any of us? Think about it. Somewhat astonishingly, USCIS adjusted Mr. Melara to LPR status in 2005. He applied to naturalize in 2015, and that is when it all hit the fan. In his N-400 application, Mr. Melara said that his mother was a U.S. citizen who had since passed away, but that his father was not. So that's not really the same as before. Mr. Melara did, however, admit to having claimed to be a U.S. citizen in the past. He admitted also to having registered to vote and to having voted, really walking the plank here. He said he hadn't ever submitted fraudulent documents, though, or fraudulent testimony to the U.S. government. USCIS was like, "You serious, bro?" Then they denied his N-336 appeal, so he exercised his federal right to have a U.S. District Court judge decide whether he warrants U.S. citizenship. And wouldn't you know it, he does. It is becoming more and more settled law that someone who gets their LPR status incorrectly, even if it wasn't through fraud, might not be able to naturalize. Courts are taking the position that such people who were inadmissible at the time they adjusted to LPR status were never, quote, lawfully admitted for permanent residence, end quote, notwithstanding their holding LPR status. Really highlighting the word lawfully, courts. Mr. Melara has many potential problems here, but most starkly is that people who have made false claims to U.S. citizenship or who have unlawfully voted are inadmissible and removable and can't become LPRs, as are people who have fraudulently or willfully misrepresented a material fact for immigration purposes. That's another ground of inadmissibility. A non-citizen's, quote, misrepresentation is willful if the statement was deliberate and voluntary and the non-citizen had knowledge of the statement's falsity, end quote. That's for the fraud or willful misrepresentation inadmissibility, but not necessarily the voting or the false claim to U.S. citizenship. And so here's where the decision gets really, really important, albeit without a whole lot of analysis. The district court held that the BIA's decision in Matter of Zhang from 2019 is not entitled to any deference at all, quote, because it is a dramatic break with past agency interpretation, is in conflict with the Department of State's current interpretation of the false claim to citizenship ground of inadmissibility, and is a break from Congress's clearly expressed intent, end quote. In effect, and while I haven't read it in a little bit, Matter of Zhang, quote, takes a dramatic and unique approach to the knowledge element out of the term false claim to U.S. citizenship, end quote. Read Zhang again, but as I recall, it essentially punishes all incorrect claims to U.S. citizenship, likely, although it hasn't really been litigated yet, including those circumstances where the non-citizen makes an honest mistake and truly believes that he or she is a U.S. citizen. But again, Zhang really needs to be litigated in the circuits. That's why this district court decision is so important. False has to mean something, says the district court. And circuit precedent indicates that the term false includes a requirement of knowledge that the statement is not true. As such, Mr. Melara never made a false claim to U.S. citizenship because at all times he believed he was a U.S. citizen. Reason the court. Also explained the court, Mr. Melara was not inadmissible for making a willful or fraudulent claim, because whenever he used his Puerto Rican birth certificate, for example, he believed it was genuine. So too, when he registered to vote, he had a U.S. passport. So too, quote, it was reasonable for Mr. Melara to rely on his passport as evidence he was a U.S. citizen when he registered to vote, end quote. Nor did he violate a federal or state law in voting or registering to vote. That law allowed him to do so, as he had a Puerto Rican birth certificate and he had a U.S. passport, and he believed him genuine. Big holdings, all of those. Now, naturalization also has a good moral character requirement, and giving false testimony will pretty much bar a good moral character finding. But the district court doesn't believe false testimony was given to USCIS, and in any event, quote, Mr. Melara's disclosure of his claims to U.S. citizenship on the N-400 and during his interview constitute a timely retraction of any seemingly false responses on his naturalization application and do not qualify as false testimony which would preclude a finding of good moral character, end quote. Restated, and I'm not 100% what the issue is here, but fixing an incorrect answer in an immigration application during the interview can be deemed a timely retraction and thus not held against the non-citizen. To the district court judge, Mr. Melara didn't start to suspect something was wrong until he began having difficulties renewing his U.S. passport. That's when he pivoted and tried to do the right thing. He tried to adjust through his U.S. citizen wife. But he never did anything false. Very important case to rely on in your most complicated of cases. If only it was a circuit saying so. It does mean, though, voila, Mr. Melara is a U.S. citizen, per order of the district court. Meaning, while it's been a couple of years, congratulations to Patricia M. Corrales and Sabrina Damast for U.S. citizen Mr. Melara. Big win. And that is Melara v. Mayorkas. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.